Nuisance ordinances are local laws that are passed by municipalities to curb undesired behaviors. These laws can range from unkempt lawns to unlicensed lemonade stands and include things such as loud music ordinances and even calling emergency services too often. The punishment for infractions of these and other nuisance laws is generally set at a misdemeanor level but can be as extensive as up to $1,000 in fines, jail time, and even evictions. These punishments can be assigned on a per offense basis. This, coupled with the desire for municipalities to generate revenue, can lead to extensive charges and abuse of the system. The consequences of criminalizing nuisance ordinances place the public in direct conflict with the police. On the public side, there is a growing frustration that comes from the belief that the nuisance ordinances are an added poor tax that they cannot defend against. On the law enforcement community side, it fosters frustration of continuous responses to the same locations and the same calls with no resolution. These frustrations often clash with devastating results that include more serious charges, injury, and even death. In 2013, Monona, Wisconsin, the city passed an ordinance stating that if a parent was made aware that their child was bullying other children and a second incident occurred within 90 days of the notification, then the parents of the offending child could be charged with permitting a minor to bully. The fine ranged from $50 to $1,000 and doubled with subsequent convictions after the first conviction. The act of bullying by itself is a nuisance law, though battery, threats, and other crimes could be involved. The ordinance here focuses on the act of bullying, which could be as simple as calling someone a name. We can all agree that bullying can be detrimental to the victim and can lead to such tragedies as self-harm or worse. This, however, does not take into consideration that other influences beyond that of the parent could be the cause of the behavior. There are free speech issues as well as culpability placed on a second party without proof of malice or intent. Other cities across the United States have adopted similar ordinances. The ordinance in Kansas City, Missouri, mandates that the parents enroll their children found guilty of bullying in an anti-bullying class or face a fine that could be as high as $1,000. In Texas, 2 girls were stopped by a local municipality selling lemonade from a stand in their yard to raise money to take their dad to an amusement park. After a public outcry, the city waived the $150 license fee, but the girls were again stopped by the state health inspector for not meeting health requirements. It took a law backed by the governor of Texas to push through a law preventing lemonade stands operated by children from being shut down. Texas House Bill 970. Nuisance ordinances are an attempt to mandate a social standard in order to a group of people. The problem with this line of thought is that many times the nuisance ordinances disproportionately affect the poor who cannot afford the fines that are associated with their issuance. If you are homeless in a municipality that has an ordinance against sleeping on public property and trespassing laws prohibit you from sleeping on private property, then there is no alternative but to break the law. No law should exist that requires anyone to do or not to do the impossible, and since we all must sleep, there is little choice but to violate the ordinance. Another example is using the bathroom in public. Many cities do not provide adequate bathroom facilities. Businesses often restrict the use of their bathrooms to customers. Those who are destitute may not have the means to be a customer and therefore cannot use the bathroom. There again, there's no choice but to violate the ordinance. Being unable to obey an ordinance not only potentially places an individual at odds with the law and those that enforce it, but it also attacks the dignity of the offender in that their own self-worth cannot be realized because they are at odds with moral standards of the community. The simple fact that an individual is incapable of obeying an ordinance makes them inherently not responsible for the disobedience of the ordinance. Furthermore, the municipality passing and mandating the enforcement of these ordinances are not doing anything to address the basic needs that lead to the infraction. Major cities have huge incentives to take away the indignity of homelessness, yet do not provide bathrooms for the public. The maintenance, upkeep, security, and supply of these facilities are always introduced as hurdles to their implementation, but the possibility of crime is not an excuse for providing services. If a public restroom becomes an area of crime, then enforce the laws that are broken and arrest offenders. If public restrooms become dens for the homeless, enforce loitering. If they are tagged, enforce graffiti laws. The potential for crime is not an excuse for the exclusion of services. We live in an age of cameras and surveillance. Monitoring properties and arresting offenders should not be an issue. Most municipalities possess anti-begging or panhandling ordinances on the books, but rarely enforce them. When enforced, it comes in the form of a sweeping action to clean up a prolonged problem or to create a more presentable environment for an event or gathering. Municipalities do not frown upon panhandling or begging performed by charitable organizations. Ironically, some of these organizations are collecting donations to aid the homeless in the U.S. Supreme Court Case Reed v. Town of Gilbert 135 Supreme Court 2218 The court ruled that restrictions on free speech must present a compelling government interest. This ruling did away with most aggressive panhandling statutes, though many municipalities replaced these violations with loitering or trespassing violations. The police can use police officers that discover evidence of a crime, even in instances where the initial stop was unjustified. That evidence, as per the Supreme Court, Case Uto v. Shreve, places the police in instances where the public may not trust them and invites stressful interactions between the police and the public. Nuisance ordinance complaints are often the precursor for larger infractions of the law. Police officers encounter frustrating situations where continuously deal with violators, and citizens encounter stressful interactions with the police over violations they feel are harassing in nature or are unworthy of the effort. Studies conducted in St. Louis County municipalities discovered that the municipalities were collecting, in some cases, upwards of 20% of their income from nuisance ordinances. Homeowners in cities like Ferguson and Pagedale reported receiving citations for such infractions as lawn maintenance, cracked walkways, and not matching colored window blinds. City officials encouraged the police to crack down on the public for infractions and often praised officers with high numbers of citations and based promotions and assignments on citation numbers. City officials also monitored the collection of fines by the courts and encouraged high fines and fees for infractions. Revenue collection replaced the primary function of public safety. On August 9, 2014, Officer Darren Wilson stopped Michael Brown. An altercation occurred through the window of Officer Wilson's patrol unit. Michael Brown then began to retreat and then turned back towards Officer Wilson, reportedly charging an armed police officer. On April 12, 2015, Freddie Gray was detained for making eye contact, then looking away from officers and running. In transport, he suffered a seizure and died from the injuries. These cases have in common that they began with nuisance complaints and ended in tragedy. The lives of the police officers were forever changed. Cities paid huge settlements, and people died. This brings us to the case of Eric Garner. New York City police stopped Eric Garner because they believed he was selling loose cigarettes without paying taxes. Police were in the area because they were responding to a fight that Garner had reportedly broken up moments before their arrival. The officer recognized Eric Garner for having sold loose cigarettes before, and they received complaints from store owners that he was selling loose cigarettes. When confronted, Eric Garner denied selling cigarettes and further stated he was tired of the harassment by the New York Police Department. When officers attempted to detain him, a struggle ensued. Eric Garner was put into a chokehold and wrestled to the ground. He repeatedly stated that he could not breathe and soon lost consciousness. Officers called for an ambulance but were not seen rendering aid to Eric Garner. Eric Garner was pronounced dead at the hospital. Nuisance ordinances are an attempt to regulate the unwanted behavior that occurs among citizens. The question that should be asked is why the behavior is unwanted, and do we need to change, or does the behavior? From kids playing basketball in the street to a man selling cigarettes on the sidewalk, there is not a single nuisance ordinance violation that is worth a person's life. Municipalities that enact ordinances designed to influence behavior must do so in a manner that removes the potential for force given by the police and replaces it with appearances with the court to hear the arguments and apply the laws. Too many times the police are used as punishment for violations that do not merit such. An encounter with the police is neither trivial nor common for anyone. With this statement in mind, why would a municipality use them to engage in incidents that most certainly will escalate? We often forget the frustrations that people trying to make ends meet face, and the simple fact that our life norms are not the norms of everyone. Financial status, relationship problems, mental illness, and simple cultural differences play a huge role in the ability to integrate into social expectations. Sir Robert Peel's Principles of Law Enforcement states the police seek to preserve public favor not by catering to public opinion, but by constantly demonstrating impartial service to the law and complete independence of policy, and without regard to the justice or injustice of the substance of individual laws, by the ready offering of individual service and friendship to all members of society without regard to their race or social standing, by the ready exercise of courtesy and friendly good humor, and by the ready offering of individual sacrifice in protecting and preserving life. Society has chosen a flawed system, and instead of correcting the system, we chose to further invest in the flaws. Nuisances cannot be ignored, and as a necessity of public order, there is a need to maintain a semblance of restraint. These laws should reflect the majority opinion of the public, not of the individual political body or the police. The potential for crime is not a crime. Those that are guilty of disturbing others need correction. Correction cannot come in acts of vengeance or as means of gain, either personally or through an organization. In an already overcrowded court system, it may be questioned how we would be expected to burden the system further with more nuisance crimes, and for those that resolution cannot be gained is jail time the option that would provide resolution. Putting more people in jail is not an option, nor should it even be a consideration, yet the only recourse for more and more nuisance ordinances seems to threaten people with jail time as a last resort. The cost and overcrowding of jails make this solution extremely counterproductive to an already burdened system. Municipalities creating ordinances that add to the burden and expense of the jail system do absolutely nothing to assist in the safety of the public. Again, if an encounter with the police leads to an arrest of a family member who cannot provide for the family, the stress of the action has made the incident worse. Further, as with the case of Eric Garner, the death of a family member adds grief, anger, and feelings of betrayal to that loss and exasperates the problems these families face. Imagine an Eric Garner incident that went something like this. A complaint is lodged that a male subject is selling cigarettes in front of a store. Eric Garner is observed through recorded footage selling loose cigarettes. He is positively identified, and a summons to appear in court with an issuance by the court is delivered by mail or by an officer. Although this type of action does little for an immediate response, there is no need for the response to be immediate. Eric Garner appears in court and is presented with the evidence against him. His altercation and argument over facts are in a non-stressful environment with a judge, and the anger over the incident does not focus on an officer that neither created nor demanded the compliance of a nuisance ordinance. The judge passes a sentence, and Eric Garner is fined and must perform community service for his crime. The court addresses any failure to pay fines or failure to complete community service. If the offense is repeated, the court can attach additional punishment. The police play a simple role in gathering evidence and are not placed in the position of adversarial confrontation. This approach does several things. Foremost, it removes the human error that is inherent in these types of high-stress events. Police officers who possess an admittedly lower understanding of the laws are subjected to split-second decisions in a high-stress environment after being taught that everyone is out to hurt them and who face an overstressed public looking to blame someone for their problems. This is not to say that every encounter that is made with police must be made this way. Negative encounters with the police can be alleviated simply by allowing the police to either gather evidence on crimes that cannot be resolved and to resolve crimes effectively and efficiently when those crimes can be. Placing a police officer as a mediator for public behavior is a recipe for disaster that leads to instances of perceived bias. Police that are exposed to prolonged or frequent stressful encounters suffer from a myriad of stress related to include depression, anxiety, and hypertension, and their performance may suffer as well as their ability to react appropriately to further stimuli. It also places an offender in a room with a judge that can make determinations over his case, whereas a police officer cannot. It removes the conflict because it places controls and structures over the interaction of the offender and the governing municipality. It allows time and space to de-escalate the encounter. Police officers cannot face every encounter without conflict, but the conflicts that are being created over laws that leave little effect on or urgency to the public do little to solve problems and do more to create a divide between the people and the police. Nuisance ordinances are not ordinances that can be corrected immediately. The actions and interactions may be halted, but the conflict that lies beneath must be answered. People want to have their side heard, and this cannot be done on the side of the road or in a public forum between a police officer and someone with elevated anger and pre-existing mistrust. We live in an era where we have grown in our technology considerably, yet we still rely on antiquated techniques to help solve our problems. A police officer patrols a street to prevent a crime. We never know how much crime is stopped, and the criminals that are apprehended are done so through blind luck. Society fears the loss of our privacy, yet demands security. CCTV has been used for years in other countries, and it has developed some surprising results. The actions of police officers have been backed by the cameras that allow a narrative of the actions to everyone involved. A higher percentage of crimes are solved when footage of the crime and criminal is recovered and used in the investigation of the case. This debunks the theory that you may have a video of the offender, but you do not know the identity. Neighborhood identification using video captured from an incident produced a higher rate of identification than simple questioning or even eyewitness testimony. Camera utilization provides the police with the tools needed to identify offenders in incidents where that identification may be hindered by a lack of witnesses to a crime. Police encounters with body cams are in high use already, and society has grown accustomed to public domains not offering privacy for the individual anymore. Police officers are often placed into situations with the public where they are faced with enforcing ordinances that have little or no public safety impact. These ordinances range from grass growing too high to lemonade stands, to people selling untaxed cigarettes. These encounters have been shown to be used by some municipalities to generate revenue and have little to do with the actual safety or security of the public. Encounters with police and offenders of these ordinances are generally high stress with little means of resolution in the moment. Using time, space, the courts, and technology can alleviate some of the stress involved in these incidents without placing officers and the public in danger. Courts generate their own income, so expanding the courts would allow the courts to process more cases and generate the revenue needed to make the expansion. It is at no fault that I view the officers as attempting to keep the peace and maintain order. The job of a police officer is challenging enough without the added conflict created by nuisance ordinances.